Counsel for the state, the jury has knocked and has informed the bailiffs that they have reached a verdict in this matter. Anything from the state?
No, sir.
Or the defense?
No, Your Honor.
Will you make the regular inquiry about making sure they have the verdict form signed and dated and in the envelope, and have the foreperson hold on to the envelope? And you may ask them to come into the courtroom, please. Mm-hmm. All right. Welcome back. The bailiff has informed me that you all knocked and told her that you've reached a verdict in this matter. I need to ask the foreperson. I'm not going to say your name because of the recording devices, but has the jury in fact reached a verdict in this matter?
Yes.
Have you reached a verdict as to each charge or count that was submitted to you?
Yes.
Have you indicated on each individual verdict form what your verdict is?
Yes.
And have you signed and dated those forms on behalf of the jury in the blank spaces provided?
Yes.
Are those forms in the envelope?
They are.
I'm going to ask you to give those to the sheriff, please. I'm going to ask the clerk to announce the verdicts of the jury.
Okay. Ladies and gentlemen of the jury, your foreperson has returned the following unanimous verdicts. In the state of North Carolina versus Jonathan Santillan, case number 13 CRS 6237, we the jury by unanimous verdict find the defendant guilty of assault with a deadly weapon inflicting serious injury. In file number 13 CRS 6235, count 1, guilty of first-degree burglary. In count 2, guilty of conspiracy to commit first-degree burglary. In file number 13 CRS 6234, count 1, guilty of first-degree murder of Maria Saravia on the basis of malice, premeditation, and deliberation, and under the felony murder rule. Count 2, guilty of first-degree murder of Jose Flores on the basis of malice, premeditation, and deliberation, and under the felony murder rule. And count 3, guilty of conspiracy to commit first-degree murder. And file number 13 CRS 6236, guilty of possession of a firearm with an altered serial number. This the 28th day of August, 2015. Are these your unanimous verdicts? So say you all.
Yes.
Is there anything else for the jury from the state at this time?
Yes, sir. Just our thanks for their service.
Mr. Cutler, anything else for the jury on behalf of the defendant?
No, Your Honor.
All right. Members of the jury, I'm going to accept your verdicts as to all counts in order that they be recorded and made part of the record. And at this time, I'm going to formally discharge you from your services in this matter. Let me explain to you, I guess, what happens from here before I release you. I have a number of things I want to say, but ordinarily and typically when a jury returns a verdict of guilty to any particular criminal offense, the court typically in state court conducts a sentencing hearing to determine what the appropriate punishment will be. In this matter, because of the defendant's age, the law requires, and the fact that you have returned a verdict of guilty to 2 counts of first-degree murder under the theory of malice, premeditation, and deliberation, the court is going to require, or excuse me, the law requires the court to conduct a hearing to determine what the appropriate punishment will be, and that is, for those 2 offenses, the 2 options will be life in prison without parole, which means life in prison without parole, or life in prison with parole. Because of his age, that's a potential or possible punishment. I am going to release you folks. You don't participate in that hearing. That's something that I will participate or I will take care of. But I just want to let you know that is not going to happen today. I'm going to reconvene Monday morning at 10 a.m. And at that time I will hear from counsel for the state and counsel for the defendant on that issue. I just want to let you know that's why this isn't going to be sentenced immediately or right away, that the law requires me to conduct a second proceeding. As I said, you're discharged from service in this matter. Your discharge is not going to take effect until you get to your final destination for today. What I'm going to do is, when I release you, I'm going to ask you to go back to the jury room. The deputies from the sheriff's department will assist you in getting out of the building through a way other than the doors that you've been coming in and out of for the last 2 weeks. And you are still technically serving as a juror till you get home. That way nobody can bother you, can approach you, can photograph you, identify you, try to talk to you about this case. They just need to leave you alone. After that, if you want to talk about this case, you may. The rules that I've given to you will no longer be in effect. So obviously you can talk about the case if you want to. If you don't want to talk about this case, you don't have to talk about this case. I tell every jury, regardless of the offense and what their outcome is, that jurors have the absolute right to be left alone. And if you don't want to talk about this case, you don't have to talk about this case. If you do elect to talk about this case, I would advise you to please be very careful in what you say, and remember that what goes on in the jury room oftentimes needs to just stay in the jury room. People say things or take positions that as you go through the deliberation process, that they would just as soon remain private. If you want to talk about the case in a positive way, please feel free to do so. Cases such as this are very difficult. It's hard for you to sit here and look at the pictures and listen to the testimony and read the things that you've read and be exposed to the things that you've been exposed to without it affecting you or bothering you. And I tell people, if this doesn't bother you, then that sometimes might be more problematic or more troubling to, if it doesn't bother you, it's more troubling than if it did bother you. So it's normal to be affected by these things, and people sometimes find comfort talking to folks to talk through the issues about how you feel about things. So if you feel the need to talk to somebody, please take advantage of that opportunity. The rules, as I said, are no longer in effect. You can watch the news, you can read the paper, you can go about your life as you choose. If in a few weeks you're going to receive a check from the clerk, it is in no way a measure of the value of the services that you've provided as a juror, but it's a per diem that the state has determined is an appropriate amount of money to help offset any expenses you may have for gas or parking or lunch or whatever. If you need a note for work, we can provide one for you. Let the bailiff know when you get into the jury room, and we will make sure that you get an appropriate note so that your employer is satisfied that you really were where you say you were. And if you need your parking card validated, make sure, I suspect you've probably already taken care of that, make sure that you do that before you leave here today. I just want to say thank you again. You know, we asked a lot of you to put your life on hold for 2 weeks to come down and listen to the evidence that we've presented to you. And I feel confident and comfortable that, you know, you were here when we asked you to be here. You were all very attentive. You took a lot of notes. And we thank you for your participation. We're here every day, every week, but we can't function without jurors. And this is a very important civic responsibility. And we appreciate the fact that you were very serious about this matter and diligent in your civic duty. That's all that I have to say to you other than a final thank you. And please, if you'll go with the sheriff, they will make sure you have all the things you need before you leave. They will collect the red badges from you. If you want to tear your notebook, your notes out of the notebook, feel free to do so. Otherwise, if you leave them in the jury room, we'll clean it out and destroy your notes. Make sure that you get all your personal belongings out of the jury room and out of the jury box there if you have anything in the box. But that's all I have to say at this point. But thank you all very much. And if at this time you would go with the sheriff, they'll see you safely from the building. Let the record reflect that all members of the jury have left the courtroom. Was there anything else on behalf of the state?
Not for the jury, but for scheduling, yes.
Yes, go ahead.
Okay. With respect to scheduling, Your Honor, I would like the opportunity to have the family here. They did indicate a desire possibly to be here, but they are now on a church trip out of town for this weekend and will be coming back on Monday. So I would ask that we actually schedule this for Tuesday morning if possible, to allow them the chance to be here. If not, we will certainly proceed and be as ready as we can, but we would ask that this actually be scheduled for Tuesday morning if possible for their benefit.
Mr. Cutler, do you wish to be heard? In my discretion, I'm going to set it on Tuesday morning. That will also give the counsel for the state and the defense an opportunity to prepare for the next process. Does the defense have anything else that you want to offer at this point?
I know it's maybe premature, but since I'm not used to having sort of a bifurcated sentencing, I would give notice of appeal. And again, that may be premature since judgment hasn't been entered. But
right.
This is, I would give that notice in the abundance of caution in case, for some reason, it does not happen at the sentencing hearing. But again, I'm probably required to do it then as well. But just in case the law requires that notice be given at this time, I would give notice of appeal.
All right. I believe that it would be appropriate to do it after we conclude the proceeding on Tuesday. But out of an abundance of caution, I have no objection to finding that you've given notice in open court and binding the matter over to the appellate division. I believe that it'll be necessary to do it again when I finish whatever we do on Tuesday, or whenever we finish that. I looked, and we don't have a traditional blue sheet. Is the defendant currently being held under a bond, Mr. Sachs? Do you know?
I do not know, frankly. I know he had been held, remember, in the youth home in Gilbert
Right.
for a long time, and has recently just made it to the Wake County Jail, so I am not familiar with his bond situation at all.
Well, I'm going to order that he remain in the custody of the Wake County Sheriff until Tuesday morning at 10 a.m. and order that his bond is, if he has a bond, his bond is revoked and needs to be held without bond. Was there anything else?
Yeah.
All right. Very well. I'm going to order that, that this session be held open until next week, and that this matter, the court's going to retain jurisdiction over the matter until Tuesday morning at 10 a.m. Was there anything else as far as?
No, sir, not for the state.
Very well. You can go back with the sheriff. All right. Thank you, Davis. All right. Yes, I'm gonna adjourn until Monday morning at 9:30 or 10 because I don't know what, they'll probably have something else for me to do. I think I may actually be unassigned next week, but other than this, but I'll just adjourn until Monday at 10.
This court will stand at recess 10 o'clock Monday. God save you.
So.